Good morning, everybody, and welcome to this breakout session during the 40th Business Law Conference of the Nigerian Bar Association section on business law. My name is Chinyere Okorocha, and I will be moderating this session today. I understand that we have two more speakers with us today, or panelists, and they are attempting to join. And at the point when they join us, I will acknowledge them. I have here today with me some eminent personalities in the field of intellectual property law, in the field of science and pharmacy. And why do we have these eminent personalities with us here today? It's because the topic we're going to be dealing with is basically titled The Price of a Cure, Patent Mechanisms in a Crisis. And just to give a little bit of background, or indeed let me introduce the speakers here today before I go on. Start in no particular order. I would like to welcome Professor Ruth Okedeji, who is actually a professor of Harvard Law School. She's an eminent personality in the intellectual property sphere. And of course, if you look at your brochure, you will see that she is well placed to discuss the topic we have here today. She's really the foremost authority on intellectual property law and is widely cited for her research in design, implementation, and IP norms, especially in developing countries. Ruth, welcome. Okay. I would also like to introduce Professor William Fisher. Professor William Fisher is also a professor at Harvard Law School, and he's currently the Wilmer Hill Professor of Intellectual Property Law. He's a director at the Berkman Center for Internet and Society and has practiced for many years in this specialist area of the law. Professor Fisher, welcome. At the point when our other speakers join us, I will also introduce them. But at this time, let me tell you a little bit about what we're talking about today. The price of a cure. The price of a cure. Patent mechanisms in a crisis. Now, as governments around the globe fight the COVID-19 outbreak, and of course, COVID-19 is a well-known, almost a household name to everybody the world over. Pharmaceutical companies are now in a race to develop a vaccine and potentially secure a patent for such a vaccine. And in the wake of this vaccine or patent sprint, questions are now arising concerning the affordability and the universal access of such a vaccine. Will governments, especially the poorer ones, be able to afford such a vaccine if it becomes available? Can a patent owner actually be forced to license their COVID-19 vaccine for the benefit of the greater good? And is there any legal framework in Nigeria that will adequately deal with the issues surrounding this? This session today is going to critically assess the current legal framework we have in Nigeria concerning patents and the patent environment in general, and whether there are any changes that we need to make in order to ensure that at the time that a patent is indeed given or a vaccine is developed, that we will actually be able to access it in Nigeria and indeed in other developing countries. At this point, I would like to welcome Mrs. Ezenduka. Stella, can you hear us?
Yes, I can hear. Good morning, everyone.
Good morning. I'm so happy that you're here. Stella Ezenduka is the current Registrar of Patents and Design at the Commercial Law Department of the Federal Ministry of Trade and Investment. Her knowledge and practice of intellectual property law spans at least 2 decades, and the strides she's making in that area are well noted. and that puts her in well stead to address this issue today. And so I think that the way we'll do it today is that we will first and foremost set the stage by understanding what is a patent, what are compulsory licensing, and what exactly are the laws regarding compulsory licensing. And the person well placed to give us some background as to what patents are, what compulsory licenses are, and how applicable they are in Nigeria is, of course, Mrs. Ezenduka, the current Registrar of Patents and Design in Nigeria. Stella, you have the floor.
Okay, thank you very much and welcome everyone. I will start by defining patent, and I will define it this way. Patent is an invention. Patent is an exclusive right granted to a person who has invented something new. It could be a process, it could be a product. And the law that provides for everything about patents is the Patent and Designs Act, Cap 344, Laws of Federation of Nigeria, 1990, or P2, Laws of Federation of Nigeria, 2004. Thank you. And we go straight to the question of compulsory licensing. Compulsory licensing for us is an authorized permit to a third party to work a patent without the patentee's consent. That's how I will define it for now. Thank you.
Yes, and then is there any other why does it become necessary to give licenses indeed, if it at all applies in Nigeria? And what are the circumstances under which such a situation will arise?
Yes, compulsory licensing is in our laws, and Section 11 of the Patent and Design Act gives effect to the first schedule, Part 1 and Part 2 of the Patent and Design Act. But the one for use of government in emergency situations is strictly on first schedule, Part 2 of the Laws of Federation of Nigeria, 2004. P2, chapter P2, 2004.
Yes. Okay, so basically what you're saying is that ordinarily, if you own a patent, you should have the exclusive right to work that patent, excluding all others from usage or getting any benefit from it. You should be able to work the patent and recover indeed the R&D, the cost that you incurred in developing it. However, the compulsory license is an exception to that rule.
This exclusive right for a patentee is lined out in Section 6, subsection 1 of the Patent and Design Act. But during compulsory licensing, it does not mean that the patentee will lose out entirely. No, because compulsory licensing portends non-exclusivity there. Which means that the patentee can go on producing or using or working his patent while the government is at the same time leveraging on that patent.
Okay.
Thank you.
Wonderful. Wonderful. So thank you so much for setting the tone today. At this point, I would like to recognize and welcome our esteemed panelists in the person of Mazi Sam Alebunwa. Thank you so much. Ohwebunwa, yes. Thank you so much.
Ohwebunwa, please.
Ohwebunwa, sir. And I'm Igbo. I do apologize.
I thought you had practiced that enough.
Yes, and just to give you a little bit of information, sir, of course, Mazi, as we fondly call him, needs no introduction if you're in the pharma space in Nigeria. Currently the president of the Pharmaceutical Society of Nigeria, as well as a past or erstwhile chairman and indeed CEO of Pfizer Products Incorporated. And that position he held in that management position for over 18 years. And so we're hoping that he will wear two hats today. He's also a government recipient of various awards. Indeed, he's an author, esteemed director in various companies, and has been chairman of the Nigerian American Chamber of Commerce. I mean, it goes on and on. So thank you, sir. Please look at the profiles of our esteemed panelists in the brochure. Now, I would like to go to Professor Fisher. Professor Fisher, could you please tell us a little bit more about compulsory licenses from an international perspective, and what has been your experience so far?
Well, a bit of background here. The system of stimulating innovation in pharmaceutical products relies on two forms of subsidy. One is grants from the government to support research that otherwise would not occur, and the other is investment by private parties. Patents are the key element in supporting the two forms of economic subsidy for innovation. Now, throughout the world, approximately 1/3 of the money necessary to support innovation comes from grants, and 2/3 comes from patents. This system has worked very well for a long time in cultivating innovation with respect to diseases that are common in developed countries. The United States, the developed portions of Europe, and Japan are the principal markets for pharmaceutical products, and diseases that are common there attract substantial investment. For diseases of that sort, compulsory licenses, which are designed to make drugs more available in developing countries, are not economically problematic. They are socially useful in affording access to otherwise unaffordable drugs. Pharmaceutical firms, however, fear the imposition of compulsory licenses, especially with respect to diseases that are not common in developed countries. And so for many years, they resisted the imposition of compulsory licenses until the clarification of international law on this issue in the so-called Doha Declaration. So the state of the law right now is that any country in the world may impose a compulsory license on a pharmaceutical product if necessary to meet a public health emergency. And that's certainly the case with respect to the COVID-19 pandemic. So one of the questions I think it's important for us to take up in this meeting is whether the exercise of this power by Nigeria or any other country would threaten incentives to develop cures or vaccines. And the short answer to that question is no, it would not. And the reason is that, unfortunately, the coronavirus and COVID-19, its principal therapeutic manifestation, are now common throughout the world. Indeed, the country in which it's most devastating right now is the United States. And the result is that the market for a vaccine right now is huge. And the added incentive that would be provided by the availability of patents unqualified by compulsory licenses in Nigeria is minimal in terms of global incentives for development. So the bottom line is that compulsory licenses can, under some circumstances, be problematic And it's therefore not surprising that pharmaceutical firms have for many years been uneasy about them. But with respect to the health challenge we are now confronting globally, a compulsory license would be unproblematic and should be used. So later in the session, I hope I can have an opportunity to suggest why a compulsory license would not be sufficient to meet Nigeria's needs. But
yes, we're certainly going to deal with the relevance of compulsory licenses further on in the discussion. But thank you very much for that. Now, Ruth, if I may, William mentioned the Doha Declaration. And I'm particularly interested in knowing, and because you have worked with the Nigerian government capacities in terms of assisting to develop the laws, being a Nigerian yourself, I'd like to know, and then the TRIPS agreement, which I know you worked on quite extensively. Where do we stand in terms of the applicability of the laws under the Doha Agreement or indeed the TRIPS agreement?
Thank you so much, and good morning or good afternoon, everyone. It's a pleasure to be here, and I'm grateful for the invitation. As Professor Fisher has mentioned, compulsory licensing should not be a problem for Nigeria at all. And in particular, under the current circumstances, I think to the extent that we are talking about issuing a compulsory license, Nigeria has never issued one in the history of our patent regulation, but our honorable registrar is here, so she might have.
Yes, she actually has a different opinion on that. I'll let her share that.
Information. So this would be great. Generally, the process for issuing a compulsory license is well laid out, both in the TRIPS agreement, which is the most recent international treaty governing patent protection globally, but it's actually predates that. So compulsory licenses have always been a challenge for the international patent system. Starting with the Paris Convention, which is where developed and developing countries really found themselves on different sides of this debate. And as Professor Fisher has mentioned, historically, and frankly, even till today, it has been a subject that has created unease, both for pharmaceutical companies and for countries that have been the primary innovators in the pharmaceutical space. In general, under the TRIPS agreement, when you think about compulsory licensing in Nigeria, Article 52, actually, I did prepare some slides. Let me see if I can,
Okay.
if I can share them. I'm not sure if I can. This technology is not one that I'm familiar with. Oh, looks like it might work actually. Let's see here. All right, can you see what's on the screen?
Yes.
Okay, great. Since you asked me a pretty direct question, I think I'm just gonna go straight here. In Nigeria, the relevant article from the Paris Convention is Article 52, which allows each contracting party the right, and I think this is really important, the right to grant a compulsory license, but to prevent abuses which result from the exercise of the exclusive rights that are granted by a patent. And I think it's important to note that in the context of COVID-19, we're talking about an emergency condition or an emergency situation that necessitates the compulsory license. So I think one example for us in Africa would be the South African issuance of a compulsory license in the wake of the HIV/AIDS epidemic, which in fact is what led to the Doha Declaration. But I wanted to point out that the grounds for issuing a compulsory license extend beyond emergencies. And so in Article 52, you can grant a compulsory license where the patent owner might be said to have been abusing the exclusive right. And really this speaks to the cost of the drug. And in the South African situation, for example, with the HIV/AIDS pandemic, ultimately the availability of the essential medicines necessary to address that in that context was resolved not really on an emergency basis, even though that's how the dispute began. It ended up really being resolved on the question of price. Can we market the drugs at a price that is affordable to average citizen afflicted with AIDS? So Article 52 of the Paris Convention sort of is the historical precursor to Article 31 of the TRIPS agreement. So Article 31 of the TRIPS agreement authorizes, so the language changes a little bit, and we're speaking to lawyers, so you can see the shift from the right to issue a compulsory license to prevent abuses, monopolistic abuses, to Article 31 of the TRIPS agreement, which authorizes all member states to use compulsory licenses without the authorization of the right holder in appropriate circumstances. So we go from Article 52 of the Paris Convention to Article 31 of the TRIPS agreement that allows member states to use this. Now, of course, to use this, you have to have a compulsory licensing mechanism in your statute. And you, of course, have to have a provision in your statutes that spell out the process and the terms on which you might obtain or issue a compulsory license. And then you asked about the Doha Declaration, particularly. The Doha Declaration, of course, paragraph 5B of the Declaration states that each member has the right to grant a compulsory license and the freedom, this is what I think is key for Nigeria, the freedom to determine the grounds upon which such licenses are granted. So the legislation needs to provide for compulsory licensing. It needs to specify the terms under which compulsory licenses can be issued. Those terms need to be consistent with the TRIPS agreement. And then, of course, paragraph 5B on the Doha Declaration then talks about the grounds upon which the licenses are granted. But of course, this is within the context of public health. You then end up with paragraph 4 of the Doha Declaration, which really expressly permits WTO members to take measures to protect the public health of its citizens. And so when you compulsory licenses, we go to paragraph 4.
Yeah, let me stop you there, because all well and good. And I will come back to Stella, who is the Registrar of Patents and Designs, because all well and good, and I know Nigeria has signed, but I'd like her to discuss the applicability of those laws currently in Nigeria. But before I come back to Stella, I would like Mazi Sam to please give us the perspective now, wearing your hat as a former CEO of a pharmaceutical company. What indeed are the challenges that you see that a pharma company would have in accepting, for or being forced to compulsorily give a license to others if they develop a vaccine or a cure?
Well, thank you very much, Chinyere.
Hold on a second, Mazi, let me unmute you. Okay, please go ahead, sir.
Thank you very much, Chinyere. And let me acknowledge the very distinguished panelists, professors and practitioners of law. I'm a layman, so let me take that caveat up front. I think that the matter is a simple matter. It is the part of motivation that drives innovation and development in the world. If people were not going to be protected from the investment they make to bring out inventions and create new realities, then there'd be no motivation to go into them. Pharmaceutical companies spend over $800 million to bring a product to the market, and out of one product they bring to the market, maybe 100 others have failed, for which they spent money even up to phase 2, phase 3 clinical trials, and they find that the adverse effects or side effects are such that they undermine the therapeutic efficacy and they abandon those drugs. So it is a painful process to bring a pharmaceutical molecule to the market, and then somebody asks you to forgo your rights to recover your investment. It is a painful thing ordinarily. However, having said so, I also appreciate that pharmaceutical companies are managed by human beings who, in circumstances like we are today, in the issue of the race to get something to deal with, help the humanity deal with COVID-19 pandemic, I believe that those can be extenuating circumstances that with some incentives can ameliorate the opposition by pharmaceutical companies to compulsory licensing. I mean that you can do compulsory licensing in any circumstances that are determined by the country is too hard a pill for pharmaceutical companies, especially those that are innovative, to bear. But if it's essentially for a global pandemic like we have in COVID, which I don't think in the last 100 years the world has faced, and which has affected the rich, the poor, the small, the big, the wise and the foolish. So it is something I believe that has a greater opportunity of being sold to global research-based pharmaceutical companies to look at the possibility of licensing. Of course, as I keep saying, whether it is in wartime or in peacetime, governments that are exercising this right for compulsory licensing must be sure that they provide some bit of soft landing for the patent owner. They provide some bit of incentive. I mean, it's at least it will suit them than just exercising the legal authority. That could create some bit of little pain in the heart of the companies. That's my take for now.
Thank you so much, sir, for those contributions. And it looks like the registrar has dropped off for the time being. I'm sure she will log back in. But in the interim, William, I'd like you to tell us a little bit more about the kind of incentives or the kind of, is it royalties? Because the point that Mazi Sam mentioned, that it can be painful for a pharmaceutical company to perhaps not get a return on their investment. What kind of incentives do you think governments should be looking at? And then what were the alternatives that you mentioned earlier that could be used in place of compulsory licenses? And I'd like you to say this against the backdrop of the fact that there are developing countries, and Nigeria is a developing country, and therefore the common man on the street will not really be able to afford a vaccine if one is when, let me not say if, because we have to be hopeful. So when the vaccine comes into the market, so against that backdrop, please, your comments.
I think everyone on this panel recognizes the importance of a vaccine in this area and the importance of ensuring that potential developers are confident that they'll recover their investment and make a profit. Otherwise, they will not enter the field. The ironic benefit of the fact that COVID-19 is so widespread already is that all potential developers of coronavirus vaccines know that they can recover their investment. A bit of context here is that 95% of the revenues earned by pharmaceutical firms come from countries 5% of the world rate. So the overwhelming majority of the revenues that are going to be received by the developer of the vaccine will not come from developing countries, they'll come from the United States, Europe. And so it's not necessary.
In your opinion, there's no danger.
Right. Now, however, I think it is important, as the previous speaker rightly identified, to ensure that we not create a climate that threatens incentives for pharmaceutical development in general. So one of the reasons why it's rare for developing countries nowadays to issue compulsory licenses is because in the past 7 or 8 years, it's been clear they have the power to do so. And against the backdrop of awareness of their power, governments have been negotiating with pharmaceutical firms to gain access to drugs on affordable prices. And in these negotiations, appropriate soft landings have been ensured. I think the appropriate approach here, the imposition of a compulsory license, which forces the firm to provide access to its technology, kind of a last resort. It's better to work out a contract under which the licensing is voluntary for modest royalties. Now, there's one other crucial element of such a contract, which is peculiar to the vaccine field. Vaccines are difficult, expensive, and time-consuming to produce. That's true even of traditional vaccines, which are cultivated in eggs. And it's especially true of some of the newer technologies that are now being experimented with for COVID. So the result is that overriding with a compulsory license the patent rights of the developer will not be sufficient to get affordable vaccines into Nigeria. It won't for 2 reasons. First, it's very difficult to produce them. And second, there is abroad internationally now an intense spirit of selfishness, national selfishness. And the governments of the United States, the EU, and Japan have made quite clear they're not going to allow vaccines to be exported until all of their own citizens are satisfied. So the result is that developing countries will be last in line to gain access to this life-saving technology. So against that backdrop, the really important challenge right now for Nigeria or any other sub-Saharan African country, or indeed any other developing country, is to ensure that it has adequate local manufacturing capacity to generate vaccines and has secured a technology transfer agreement from the pharmaceutical firm to ensure that advisors make themselves available to assist the local manufacturers in producing the vaccine. That's the key element. It's not just gaining access to intellectual property rights, it's gaining access to the know-how necessary to actually produce the vaccine in Nigeria. That's the thing that needs to be worked on.
Thank you so much for those comments, and that's really knocking the nail on the head, and that's the crux of the matter, especially because it's most likely, I should say, that the vaccine would come from the Western world, and if those countries have categorically stated, or by all intents and purposes, have given an indication that they will take care of their own citizens first, then the developing world and countries like Nigeria are low on the spectrum. But now that our Honorable Registrar of Patents is here, Stella, I would like to find out, I have a couple of questions for you, but first and foremost, oh dear, we have lost her again. Okay, so I'll come to you, Ruth. In the light of the fact that Nigeria, and indeed all the developing countries, will be last on the list if a vaccine or when a vaccine is found, what do you think the government of Nigeria should be doing at the moment in order to ensure that we are well placed to take care of our citizens? William mentioned local manufacturing, and I'm aware that only about 30% of the pharmaceutical products being used in Nigeria are manufactured locally. About 70, and indeed, in some cases, 80% of the pharmaceutical products are imported. What's your advice? And I would like Mazi Sam to also take that question after you.
Thank you so much. So I really want to push back a little bit on the assumption that Nigeria has no productive role to play in the development of a vaccine. When you look at the statistics, at the numbers in terms of both Nigerian scientists, industrial capacity. Now, this is speaking not to potential, which is significant. This is still speaking to the reality of how many Nigerian scientists, from biomedical engineers to pharmaceutical scientists around the world exist. It's interesting to me that the government has not yet invested in pulling together a team at the national level to ask this very question. What does Nigeria need to do in order to be part of the race to find a cure, perhaps a vaccine, but also treatment? Because this is not just about the production of vaccines, which would be the most important thing at the top of the list, but it is also about treatment, because as we know from the scientific studies so far, the coronavirus in particular has had a much more devastating effect on Black communities. Now, this is partly poverty, but it is also likely to have some genetic and cultural vulnerabilities that in phase 2 and phase 3 testing, Black people are not likely to be the majority of people that are involved in clinical trials, and certainly living in the conditions that we find ourselves in most African countries, it's unclear the extent to which exact transfer of the technology or of the treatment is in fact going to be therapeutic within the Nigerian context. And Nigeria in particular has a history of this. For those of you on this program who are old enough to remember, there was the adverse reaction to the polio vaccine, for which many Nigerians today continue to carry. And this was not just in Nigeria, it was actually in several African countries where adverse reactions to vaccines created fairly significant health problems. And so I think that the Nigerian government needs to be pooling together the really quite important and significant scientific cadres to begin thinking about how we are going to utilize and expand local production capacity, but also to begin looking at R&D. So the Nigerian Pharmaceutical Research Corporation, which many years ago was really active in pharmaceutical research and development in Nigeria. The question is, where is it now? What is it doing in response to COVID-19? What kind of data can be added to what's happening around the world for purposes of making sure that any vaccine that is discovered and created is in fact therapeutic and efficacious in the Nigerian context. These are some things that I think are really critical. And, because you can't talk about a compulsory license, it doesn't matter what the price is. There is no vaccine currently today, and we have no treatment for this disease today. And so it is vital that we are thinking nationally about how to dig into the resources that we have to begin to produce the data within Nigeria for purposes of treatment and for participation in vaccine development.
Thank you so much for that, Ruth. Thank you. We do need to look inwards. Stella, if you could please address the issue of where our current laws stand. Are we covered legally in terms of implementation of compulsory licensing, or indeed any other infrastructure we want to use to tackle this pandemic? What do our laws tell us, and are there lacunas in the law that you can point us to? And then
there are so many, but I cannot. Thank you very much. There are so many, but I cannot actually now discuss it extensively, exhaustively. But our laws, we should bear in mind that our laws, as far back as 1970, nothing has been done to it. So it needs review. It needs review to accommodate contemporary issues of compulsory licensing. Compulsory, who determines and the main that's
I think the internet is a bit shaky. Is it just from my end, or is Mrs. Ezenduka's voice a bit shaky?
It is.
I believe the point she was trying to make is the fact that at the moment it's only the minister that can decide who gets the compulsory license and who doesn't. And usually it's at his discretion. And so what criteria is he using to determine who should get the license? Stella, I hope I got that right. Was that what you were trying to say? Okay.
Chinyere, if I might just jump in
okay.
there.
And it hasn't improved. Okay, I'll just quickly move to Stella, just hold that thought and let's see if the internet connection will improve. I'd like to, Mazi, to answer the question I posed earlier on. Basically, in terms of the remuneration, was it, of those who are compelled to give the compulsory licenses? And then what do we think Nigeria should be doing at this time? So I guess in this case, I'd like you to wear your policy hat as president of the Pharmaceutical Society of Nigeria. What should we be advising the government to do at this time before the vaccine becomes available? Just in line with what everybody is doing globally, what all nations and governments are trying to do globally.
Thank you, Chinyere.
The minister as
I think there are two or three issues. I think we have to put Stella off. She's still trying to speak. You have to mute Stella.
Yes, she's muted. She is muted, sir. Can you hear her?
Okay.
Yes, she's muted. Stella, I do apologize.
All right.
I'll come back to you and see the internet connection improved from your end.
You people have muted me. You muted me.
Please go ahead.
So I want to say there are two or three things government should be doing, and also in response to what the other speakers have said. First is we should do the first. I think there are 2 points here. First is to find a way by which Nigeria can participate in some aspects of the scientific activity going on now with vaccines and curative products. We must find a way, the minimum being to participate in the clinical trials. We should be able to attract that some of the clinical trials going on this vaccine should be done in Nigeria, because they are looking for countries and volunteers. So if we get our clinical trials, protocols, and environment attractive, then we should attract some of these trials in Nigeria. And that will be some kind of investment in this procedure. That's the least thing we can do. Number two, as Professor William Fisher said, we also will need to build some capacity. I mean, I think it was Ruth who said, so we need to build some capacity locally. And I think that's one of the things the central bank has started to do by supporting, providing some particular branch of money for pharmaceutical companies to develop. But I think the government ought to be more directed in identifying area of focus. Today, pharmaceutical companies are allowed to choose what to do, what to invest their money in, and so forth, without any vision being provided by government. Government also say today what we need is a vaccine capacity. How many companies are going into vaccine production? Then we can then talk with CBN to provide the additional funding or special funding for that. Yes. The government has no, they are not interested. We have to beg them even to call in professionals to talk on COVID-19. The NDDC and government and Ministry of Health were running it as a private enterprise, and they didn't want anybody else to participate, to sit down and be giving us figures every day. So we have to fight, even the professional group, PSN and MA, to be allowed to participate, to provide some feedback and information on what is going on. It was a fight. So it is confusing that our country is not optimizing the opportunity that is available. There are too many things that are done nominally. You know, we're looking at this, we want to do this, you know, but on the ground, not much is happening. The National Institute of Pharmaceutical Research and Development 5 months ago developed a protocol even to try a local pharmaceutical formulation, a herbal preparation, which they thought could be useful in managing symptoms, if not the COVID disease. I think maybe in the last 1 or 2 weeks that they are getting some bit of funding for 5 months. And people have donated money, individuals, corporate organizations, and they just put the money in central bank. I mean, looking at the money every day, every morning, every evening. Somebody's looking at it, I call it TSA. So somebody just watching how the money is being preserved. Instead of investing it in the productive sector or to create innovation or new ideas. So I think our own government is not doing well. I hope that other people...
So whose job is it to get your government to do this? Through what we as stakeholders and practitioners in this area? Because the Honorable Senator was meant to join us on this panel, but unfortunately, he was called away to Abuja for an important meeting, and that is the chairman of the Senate Committee on Health, Senator Oloriegbe, was meant to be on this panel. And we particularly wanted him here because we don't just want to have an academic discussion. We want to table these issues so that someone takes it back to the government to ensure that some policies are made towards it. We just don't want to talk and go away and nothing happens. So whose role is it, sir, to bring this to the attention of the government? Is it you and I?
Well, that's what I just told you, that we had to fight, almost physical fight, to get Federal Ministry of Health, the NCDC, to allow professional groups like the Pharmaceutical Society of Nigeria, Nigerian Medical Association, Nigerian Association of Medical Labs, to participate in even discussing what is going on. We have to force ourselves. So the work is to force, and the way to force it is professional groups like MBA, PSN, to force government, because government sometimes is full of good intentions, but getting things done becomes an issue. So I think that that's what we need to do. Force the issue, put it on the burner. Sometimes they say we are making trouble, but that's the only way to get them to react. When you make some trouble, then they pay attention. But if you are not just making any trouble, they are busy doing irrelevant things and putting money where it's not going to yield the appropriate return.
Thank you, sir. You're obviously so passionate about this. I can see. very passionate about Nigeria and about implementation of proper policies. And so I do thank you for that. Our time is fast spent, and I would like us to look in the question and answer box with the few minutes we have left. And then I will call for closing remarks from each of the panelists, which I hope will just be about a minute long. A part of the discussion I wanted to take today, but because of time, we probably haven't, is the place of parallel imports, and then the place of, I guess, cross-border or transactional agreements in trying to deal with this COVID issue. So anyone who wants to throw in a little bit about those two topics when they're giving their closing remarks, I'd love to hear that. But in terms of questions, I believe there's one here that I find quite interesting. So it says, and I'm reading here. Both South Africa and Brazil can show how compulsory licensing as a public health issue ends up being determined by business negotiation. Oh, as if they heard me. Do you think a novel global pandemic such as COVID can deter pharmaceutical firms from challenging compulsory licenses on the basis of public policy? And I would like to throw that question to you, Ruth.
So thank you so much. And I wanted to say thank you to Mazzy Sam, because I think it's very gratifying to know the intensity with which the pharmaceutical sector is pushing the government. This is really important. Let me just say very categorically on this panel that every Nigerian life matters. Every Nigerian life is just as valuable as any other life. And so it is worth it to really push policymakers to address the public health challenges in Nigeria. So first, there is the legal framework that must be addressed. In the current statutory framework in Nigeria, it takes 4 years to be able to apply for a compulsory license. So let's assume that we had a miracle cure today for COVID-19. It would take 4 years to even begin to be able to apply for a compulsory license.
But I understand the minister can intervene and call for it sooner.
Yes, but remember that in countries like Brazil, there are 9 different ways to get a compulsory license. So why not engage in some legal reform? Private actors in Brazil can apply for a compulsory license. So the reality is our laws are not even adapted to the agreement. Yeah. And we're very casual about the value of Nigerian lives. And this is something that the Bar Association, I think, needs to take seriously, because it's a legal question about being entitled to what the law and what the international treaties enable the country to do that are not being done, even in terms of legal reform. I think the second thing is really critical, and Mazzy Sam has hinted at this. At least all of the data that I have looked at, Nigeria has the capacity in its traditional knowledge herbal medicine sector to begin to investigate some therapeutic cures. And these, of course, can sometimes be patented, sometimes not. There are other forms of IP that could be used. But even to invest in local R&D in the herbal sector, the traditional knowledge sector, is a vital part of addressing this question. It will be some time before we get a vaccine. And that does not mean that Nigerian lives should be perishing in the period of time that occurs.
I'm so glad you mentioned the point about the local remedies, because I'd love to address that to you. Okay, Stella has gone off again, because there's a question here that says, we have witnessed numerous homegrown inventions recently. Unfortunately, some may not qualify for patent protection. Isn't it time for Nigeria to consider utility models or petty patents? And that's exactly the point you were making, Ruth, that they may not qualify for patent protection, but however, they may qualify for utility models or such the like. Is that the point you were making?
Well, frankly, as Professor Fisher, for those of you who don't know, actually taught me many years ago at Harvard Law School. So everything I'm saying, I learned from his class.
Okay, so let's ask him. Let's address.
So I think he needs to jump in on this and on this question. But I'm so sorry that Stella had to drop off.
Yes.
The reality is that Nigeria's patent law is outdated. We inherited a set of laws of independence in 1960. The 1970 Act essentially replicated the colonial statute with a few modifications, and we're still in 1970, even though the law says 1990. The substance has not changed.
It does have to change, really. And Professor Fisher, just to give us a rounding up comment, what do you say? And I will unmute you. Just give me a second. There you go. Okay.
I agree with all of the comments that have been made on this panel, which I found extremely helpful. I will say in closing only that if the pharmaceutical industry in Nigeria or the government, or ideally both working together, were interested in some technical assistance in this regard, Professor Okedechi and I worked together in providing advice to some African countries on updating their laws. And we would be happy to provide free assistance on some of the issues that have been mentioned in this panel. So
thank you so much, sir. Thank you very much. That's really good to note. Mazi Sam, some closing comments?
Well, the comment I have to make is just to harp on the last point that we seem to be making, is that our government, maybe many countries in Africa, let's not be like I'm challenging this government too much, are not up to speed in trying to protect their citizens. They think that the lives of their citizens are expendable, they are worth nothing. So that is why until COVID came, nobody remembered to build good hospitals or get a functional health system. So I think our focus as professional group is to put pressure on these guys and tell them to wake up. We have opportunities to produce the least we can. We have opportunities to manage our space the best way we can, get our laws enforced, avoid all the things you spoke about, parallel importing, illegal importation, and all the funny things that go on in our country, and be a country that has laws that it can enforce. Thank you.
Thank you so much, sir. Thank you. And Stella, would love to get, it's just unfortunate that the internet bandwidth was a bit shaky and you had to drop off every now and then, but please give us some last thoughts that you'd like to share with us regarding the issue at hand. Stella? Mrs. Ezenduka? Hello? Unfortunately, it looks like we may not be able to get those last comments from Stella. Our time is fast spent. Hello, Stella? Hello? Perhaps if you switched off the camera. Okay, and she has dropped off again. Okay, I would just like to say a huge thank you to my panelists. You have been fantastic. From Professor Fisher to Professor Okedechi and Mazi Ohwebunwa. I hope I said it well, sir.
I will sue you. I'll sue you.
And many thanks.
I'm sure Professor.
Yes, sir.
Professor William will offer me free legal support.
And many thanks to all the panelists, and indeed Mrs. Stella Ezenduka, who is our Registrar of Patents and Designs. Thank you for a very engaging session. I believe that our work is cut out for us, and we need to form that advocacy and pressure group to articulate all the issues raised here today, to put it into a position paper. I'm sure the SBI will come up with that. And indeed, as a pressure group to the government to take the necessary steps that it needs to in order to ensure that when a vaccine is found, that Nigerian citizens will benefit from it at a reasonable cost, that our laws need to be updated, and indeed, all the money, like Mazi Sam has mentioned, philanthropic activities from generous donors, some of it needs to go into the health sector, indeed, in terms of developing capacity and improving the infrastructure and updating our laws. So thank you, everybody, for a very, very interesting session. I thoroughly enjoyed myself, and let us hope that the price of a cure for Nigeria will not be one that we cannot pay. Thank you, everybody, and have a good day. Thank you.